Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Prostitution Attorney, Chicago, Illinois. If you're facing a prostitution charge in Chicago, Illinois, it's important to speak with an experienced criminal defense attorney as soon as possible. A prostitution-related conviction can carry serious consequences under Illinois law, like jail time, large fines, and long-term damage to your reputation and future. Whether you've been accused of solicitation, patronizing a prostitute, or another sex-related offense, you deserve a strong legal defense. At Combs Waterkotte, our criminal defense lawyers have decades of combined experience defending clients against sex crimes charges, including prostitution, in Chicago and throughout Illinois. We understand how stressful and overwhelming these allegations can be, and we're here to fight for your rights, protect your future, and pursue the best possible outcome in your case. Call 312-500-HELP today to get started on your defense. Prostitution Attorney in Chicago, serving all of Cook County, Illinois. Prostitution charges in Chicago and throughout Cook County, Illinois can quickly disrupt your life, career, and your reputation. Prosecutors in Illinois often pursue prostitution cases aggressively, and a conviction can lead to a slew of negative collateral consequences. If you've been arrested or accused of a prostitution-related offense in the Chicago area, you need an experienced criminal defense lawyer on your side as quickly as possible. At Combs Waterkotte, we understand that prostitution allegations can arise from misunderstandings, mistaken identity, or isolated lapses in judgment. Our team takes the time to understand your side of the story and build a defense strategy tailored to the facts of your case. With decades of combined criminal defense experience, we know how to challenge weak evidence, identify procedural errors, and negotiate aggressively to seek reduced or dismissed charges whenever possible. From the moment you choose our firm, we'll work to protect your rights, your reputation, and your future. Whether your case can be resolved through negotiation or requires a trial-ready defense in court, Combs Waterkotte is prepared to fight for the best possible outcome for you. If you're ready to take control of your defense and fight back against prostitution charges in Cook County, call Combs Waterkotte today at 312-500-HELP or contact us online for a free, confidential consultation. Prostitution laws in Chicago, Illinois. The Illinois Criminal Code defines several prostitution-related offenses. Illinois law categorizes prostitution under its sex offenses section, covering everything from the sex workers themselves to the individuals who request and pay for their services. The following prostitution-related offenses are covered under Article 11, Subdivision 15 of the Illinois Criminal Code. Prostitution. 720. IDRL CS 5/11-14 defines the offense of prostitution in Chicago and Cook County as knowingly performing, offering, or agreeing to an act of sexual penetration or fondling of the genitals of one person by another for the purpose of sexual gratification in exchange for money or valuables. This is the general prostitution statute, and it covers sex acts in exchange for cash or property. Like many offenses under Illinois law, prostitution requires knowing participation in the offense. Solicitation of a sexual act. Under 720 ILCS 5/11-14.1, a Chicagoan commits solicitation of a sexual act when they offer another person money, property, or anything of value to another person to perform an act of sexual penetration for the purpose of sexual arousal or gratification. Similar to inchoate offenses, a person does not need to partake in a sexual act to be charged with solicitation of a sexual act. Merely asking for sex for money is enough to face these charges. Promoting prostitution. Promoting prostitution in Chicago, Illinois is covered under 720 ILCS 5/11-14.3. The statute defines this offense as compelling another person to engage in the sex trade or arranging a situation where a person may practice prostitution. Before the large revisions to the Illinois Criminal Code in 2011, this offense used to be called pimping, a common and widely understood term in the sex trade. Patronizing a person engaged in the sex trade. Covered under 720 ILCS 5/11-18, the offense of patronizing a person engaged in the sex trade in Chicago occurs when an individual engages in an act of sexual penetration with a sex worker, enters or remains in a place of prostitution with the intent to have sex with a sex worker, engages in touching or fondling with a sex worker to achieve sexual gratification. While this crime sounds similar to the standard Illinois prostitution statute, its purpose is to target people buying sexual services at brothels and other prostitution businesses or locations. Repealed prostitution offenses in Chicago, Illinois. When legislators reworked large sections of the Illinois Criminal Code in 2011, several prostitution-related states were repealed and rewritten. The following prostitution offenses were repealed in July of 2011 under Public Act 096-1551, 720 ILCS 5/11-14.2, first offense for felony prostitution, 720 ILCS 5/11-15, soliciting for a prostitute, 720 ILCS 5/11-16, pandering, 720 ILCS 5/11-17, keeping a place of prostitution, 720 ILCS 5/11-19, pimping. These changes were made to the Illinois Criminal Code to address modern developments in prostitution in the Chicago and Cook County area, including online prostitution ads, soliciting sex work via email and text messages, and paying for sexual favors through currency exchange applications. It's important to note that while these statutes were repealed, the offenses themselves were not made legal. They were simply reorganized into new sections of the Illinois Criminal Code. Penalties for prostitution in Chicago, Illinois. In Chicago, Illinois, prostitution may be charged as a felony or as a misdemeanor, depending on the circumstances of the offense. Prostitution and solicitation of a sexual act are charged as Class A misdemeanors, a conviction for which may result in up to a year in jail and a fine up to $2,500. Sentencing in these cases often depends on the criminal history of the offender. Promoting prostitution and patronizing a person engaged in the sex trade, however, are charged as felonies. While the baseline offense is a Class 4 felony, committing either act within 1,000 feet of a school results in a Class 3 felony charge, as does a second or subsequent offense. A conviction for a felony-level prostitution offense may also result in several collateral consequences for Chicago and Cook County residents, alongside damage to your personal reputation. Some of these collateral consequences include child custody and visitation consequences. Chicago family courts may restrict custody or visitation if prostitution-related felonies suggest unsafe environments, criminal instability, trafficking involvement, or conduct deemed contrary to a child's best interests. Firearm rights. A felony prostitution conviction generally results in loss of firearm possession rights under Illinois and federal law, potentially permanently barring firearm ownership or FOID eligibility. Immigration consequences: felony prostitution offenses can trigger deportation, inadmissibility, visa denial, or removal proceedings, especially where allegations involve trafficking or organized criminal activity. Employment barriers: felony prostitution convictions frequently appear on background checks, limiting employment opportunities, professional licensing eligibility, security clearances, and jobs in Chicago involving vulnerable populations or public trust. Housing issues: a prostitution-related felony may complicate rental applications, public housing eligibility, or housing assistance, especially when Chicago and Cook County landlords view the conviction as evidence of criminal activity. What to do if you're arrested for prostitution in Chicago, Illinois? What you say or do in police custody after a prostitution arrest in Chicago can make or break your case. At Combs Waterkotte, our Chicago area criminal defense attorneys recommend exercising the following rights at all times after an arrest on prostitution-related charges. Don't answer any questions without a lawyer present. After a prostitution arrest in Chicago, avoid discussing the allegations with police, detectives, or investigators before speaking with a criminal defense attorney. Chicago Vice units and Cook County prosecutors often rely heavily on statements made during undercover sting operations, hotel investigations, and online solicitation cases. Even casual explanations or attempts to clear things up can later be used against you in court. Invoke your right to remain silent and request legal counsel immediately after your arrest. Contact a Chicago criminal defense lawyer immediately. Prostitution cases in Chicago often involve undercover operations, digital evidence, vice investigations, and aggressive prosecution tactics. A defense attorney can evaluate whether police violated your constitutional rights, improperly induced sex-related conduct, or lack sufficient evidence for conviction. Early legal intervention may also help negotiate reduced charges, diversion programs, favorable bond conditions, or case dismissals. Because Illinois prostitution laws contain multiple overlapping offenses, retaining an experienced Chicago criminal defense lawyer quickly is one of the most important steps to take after an arrest. Avoid discussing the case online or by text. Chicago prostitution investigations frequently involve digital evidence, including text messages, escort advertisements, dating apps, hotel records, and social media communications. Prosecutors may subpoena electronic records or use screenshots during criminal proceedings, so avoid posting online, deleting messages, or discussing the allegations with friends, co-workers, or romantic partners through text or social media. Statements made electronically can easily become evidence in Cook County Criminal Court and may complicate your defense strategy later. Understand the exact charges filed against you. Illinois law contains several prostitution-related offenses. Each charge carries different penalties and long-term consequences. In Chicago area cases, prosecutors may also add trafficking, narcotics, or conspiracy allegations depending on the circumstances. Understanding the precise offense filed against you is critical, because misdemeanor and felony prostitution charges can dramatically affect sentencing exposure, immigration consequences, employment opportunities, and future criminal records. Preserve any evidence that may help your defense. Important evidence in Chicago prostitution cases can disappear quickly. Save text messages, rideshare receipts, hotel confirmations, GPS records, surveillance footage information, and witness contact details as soon as possible after your arrest. In many undercover prostitution stings, the defense may challenge police conduct, mistaken identity, intent, or entrapment issues. Preserving favorable evidence early may help your attorney dispute the prosecution's narrative or identify weaknesses in the government's case before trial or plea negotiations begin. Stay away from alleged co-defendants or witnesses. After a prostitution arrest in Chicago, prosecutors and judges may closely monitor contact between defendants, witnesses, or alleged trafficking participants. Communicating with other individuals involved in the investigation could lead to witness tampering allegations, bond violations, or even additional criminal charges. This is especially important in cases involving massage businesses, escort operations, or alleged trafficking enterprises. Follow all bond conditions carefully and allow your lawyer to handle communication related to the pending case whenever possible. Understand the potential long-term consequences. A prostitution conviction in Illinois may create consequences far beyond fines or jail time. Defendants can face employment barriers, immigration problems, housing difficulties, professional licensing issues, and reputational harm. Chicago area prostitution stings also sometimes generate media coverage or online mugshot exposure that can affect personal relationships and careers. Understanding these long-term risks early allows defendants to make informed decisions about plea negotiations, diversion opportunities, trial strategy, and whether pursuing record sealing or expungement may later be possible. Criminal defense strategies for Chicago prostitution charges. A Chicago prostitution conviction can result in months or even years in jail. That's why hiring a criminal defense attorney to handle your case is essential. At Combs Waterkotte, we've helped Chicago residents fight prostitution charges before, and we've found the following criminal defense strategies to be particularly helpful at securing favorable outcomes in these cases. Entrapment during Chicago vice sting operations. Entrapment is one of the most common defenses raised in Chicago prostitution cases involving undercover police operations. Defendants may argue law enforcement improperly pressured, persuaded, or induced conduct that they otherwise would not have taken part in. This issue frequently arises in online solicitation investigations, hotel stings, and undercover escort operations conducted by Chicago police or Cook County task forces. If officers crossed legal boundaries during the investigation, the defense may seek dismissal or suppression of evidence obtained through improper tactics. Challenging illegal searches and seizures. Fourth Amendment defenses may apply in Chicago prostitution cases where police unlawfully search phones, hotel rooms, vehicles, homes, or electronic accounts. Chicago area law enforcement operations often rely on digital evidence like text messages, advertisements, payment applications, and GPS data. If officers conducted a search without a valid warrant, consent, or lawful exception, the defense may challenge the admissibility of critical evidence. Suppressing this evidence can significantly weaken the prosecution's case or potentially lead to dismissal of the charges. Arguing lack of criminal intent. Many prostitution offenses under Illinois law require proof that the defendant knowingly intended to exchange sexual conduct for money, property, or other valuables. In some Chicago and Cook County prostitution investigations, messages, conversations, or encounters may be ambiguous or misinterpreted by police. A defense attorney may be able to argue that there was no actual agreement, no intent to commit prostitution, or no understanding that illegal conduct would occur. Without sufficient evidence of criminal intent, prosecutors may struggle to prove the offense beyond a reasonable doubt. Challenging statements made to police. Fifth Amendment and Miranda rights-related defenses often arise after prostitution arrests in the Chicago area. Defendants sometimes make statements during stressful undercover operations or police interrogations without fully understanding their rights. If police failed to properly advise a defendant of their Miranda rights or continued questioning after they request counsel, the defense may seek to suppress those statements. Excluding incriminating admissions can limit the evidence available to Cook County prosecutors during plea negotiations or trial proceedings. Defending against misidentification allegations. Chicago prostitution stings sometimes involve crowded public areas, online communications, hotel surveillance, or rapidly evolving undercover encounters. In certain situations, police may incorrectly identify the person allegedly involved in the offense. A criminal defense attorney may be able to use surveillance footage, witness testimony, digital records, GPS information, or alibi evidence to challenge the prosecution's identification of the defendant. Misidentification defenses can become especially important in cases involving shared phones, online ads, or multi-person investigations. Attacking weak or circumstantial evidence. Chicago prostitution prosecutions may rely on circumstantial evidence rather than direct proof of any illegal activity. Prosecutors may attempt to build cases based on the use of coded language, cash possession, hotel visits, or online escort ads. However, suspicious circumstances alone may not necessarily establish guilt beyond a reasonable doubt. A defense lawyer may challenge whether the evidence actually proves a prostitution offense occurred. Demonstrating gaps, inconsistencies, or alternative explanations of the evidence can create reasonable doubt and strengthen the defense during trial or negotiations. Negotiating reduced charges. Not every prostitution case in Chicago proceeds to trial. In some situations, defense attorneys can negotiate reduced charges, supervision, deferred prosecution agreements, or other alternatives to jail time. This can be particularly important for first-time offenders, nonviolent defendants, students, or non-citizens facing immigration concerns. Skilled negotiation can sometimes help defendants avoid permanent criminal convictions or minimize long-term consequences associated with prostitution allegations. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.